Let me go on to Priest for Life case. The free exercise clause of the First Amendment ensures that each person has a freedom of conscience to pursue their own religious values. These rights end where they would interfere with another's ability to do the same. However, in recent years, a wide range of individuals and institutions have received special dispensation to impose their beliefs in others. And of course, most notably, this is the Hobby Lobby versus Burwell case. So a case that raised those kinds of issues came before you in the Priest for Life. And in that case, one of the things you had to determine was whether there was a substantial burden on the employers. And their employers, their claim, the act of filling out a form to let their insurance company and Health and Human Services know that they had a religious objection, weren't going to cover the contraception, was overly burdensome. And it wasn't the priests who were providing the contraception coverage, a third party was. And the priests weren't forcing that third party to cover birth control. Congress was through the ACA. In your dissent, you thought that was too much. You said the employer's religious exercise was substantially burdensome and that they could deny contraceptive coverage to their employees. So my question to you is, do you believe that the freedom of religion clause supersedes other rights?
No, Senator, I made clear in that decision that the Religious Freedom Restoration Act has a three-part test. First, substantial burden. I found that satisfied there based on the Hobby Lobby precedent, which I was bound to follow in the Wheaton College. Second, compelling interest. I did find a compelling interest there for the government in ensuring access. And then the third prong is least restrictive means. And I made clear there, I cited Reva Siegel's law review article, made clear the...
Let me get to the first prong, which is whether this was unduly burdensome. So you determined that filling out a 2-page form was unduly burdensome. Did you know?
I concluded that penalizing someone thousands and thousands of dollars for failing to fill out a form when they didn't fill it out because of their religious beliefs was...
No, if they filled out a 2-page form, they could have been totally insulated from thousands and thousands of fines. So the question became not the fines, that was irrelevant. The question was whether a 2-page form was overly burdensome, and you determined it was overly burdensome. So, you know, it kind of defies logic to me. Let me go on to what I would consider to be a related case, which is Garza v. Hargan. And I would consider these two cases as being related because, first of all, they are both cases about women's reproductive freedom. And second, while you balance the interests of the parties involved in very different ways, you come to different conclusions. What's similar is, in both cases, you ruled against the women. In Garza v. Hargan, been brought up before, you argued that the government's basically charade of trying to keep a young woman in custody until it was too late to get an abortion was not an undue burden on her rights. So forcing her to remain in HHH's custody and, in fact, considering this to be a parental consent case, which was not the case, it was irrelevant. And in Priest for Life, you insisted that a government requirement that religious employers filled out a very short form declaring their objection to providing health care was too much of a burden. And in each case, you reached your desired outcome, which is against women's reproductive rights. And you ignored the common sense meaning of burden. By the way, filling out the 2-page form, the majority opinion did not consider that overly burdensome. And you know, I really think that your conclusions that filling out this form is overly burdensome defy logic. But it is logical in the sense that in both cases, you were against women's reproductive rights. So how is it possible for me to draw any other conclusions that basically you really want to limit a woman's reproductive rights? So even though you engage in a balancing test, in the case of Priest for Life, filling out a 2-page form was too much. But in the case of Garza, it was not too much to have this young woman remain in custody and to be forced, as far as you're concerned, to wait around for foster parents to be found.
In each case, Senator, I was doing my best to apply the precedent on point. the Hobby Lobby and Wheaton College case. The Wheaton College case had dealt with a form, and so I followed as best I could the Wheaton College case. The Supreme Court had, I think, a 6-3 vote, found or granted an emergency injunction in that case. I tried my best to follow that precedent.
See, that's the thing about following precedent, because, you know, oftentimes your own perspective, a judge's ideological viewpoints, et cetera, come into play as to which precedent to apply, how to apply the precedent, and what parts of the precedent you want to apply. Let me get to something that should be really simple.